Well, basically the project is all about simulating the Supreme Court, specifically the active roles that are in the Supreme Court, whether you're arguing for the plaintiff or the government, and the interaction between those parties and the judges based on constitutional principles. Well, for a public school project like this, you really need to have a level of enthusiasm. There are some other case topics that we could have chosen, but nothing really gets people going like the death penalty.
Are you ready for this?
I was born ready, sir.
Yeah, I'm ready for this.
I'm just nervous. I hope we win. Go government.
Chief Justice and if it pleases the court. The government wrote, and I quote, "After all, if the framers had not viewed it as cruel and unusual punishment in the late 1700s and declared it to be an obstruction of constitutional privileges then, when it was much more insensitive, painful, and barbaric than it is now, why would they change their minds now?" The noose, for example, was supposed to be a quick way to kill someone. Their neck will snap, they won't feel it, it'll be over. But when the rope is too short, they'll choke there for up to an hour, dying painfully, suffocating. And when it's too long, their head will be ripped off, blood and head flying.
But we're not talking about hanging someone right now, we're talking about lethal injection.
Right. Yes.
So what does that have to do with anything?
I'm about to get to that. Would you like me to go to that right now? Or?
Please.
Lethal injection is the same way. Instead of the storybooks way of it, where the person will peacefully drift to sleep, never to wake up, it does not happen like that in real life.
What storybooks do you read?
The point is that it is cruel and it is unusual.
How is it unusual if it happens every day?
Okay. And first off, it says cruel and unusual. It can't be either of those. So it may not be completely unusual, but if it is cruel, then it is unconstitutional.
If it's not completely unusual, then you're just disregarding the statement that it has to be both. So
It doesn't have to be both.
That would be cruel or
It says cruel and unusual.
Let me see if I have the exact wording.
It is cruel and unusual, not or.
I know, but it says
So if
not
it's
cruel.
not unusual, it has to be both.
It says no punishment can be cruel and unusual, right? So if it's either one, then there's a negative statement. So it can be either, if it's either cruel or unusual, then it's unconstitutional.
Do you know that from the thing?
I'm not an anesthesiologist, I'm not a Columbia University professor. That's the conclusion that he drew.
He drew the conclusion that it was from the paint. He drew the conclusion that it was from the paint that made it crack.
Yes.
And he knew this happens. Did he ask him?
He's a Columbia University professor, and I think he probably knows what he's talking about more than me, and maybe you.
I think Evan did a really good job. He sort of jumped around questions, but in a good way, in a way that he didn't want to get stuck on, and I think the information presented was really bad. Jonathan Yin was acting like kind of a jerk, and I don't think it's going to affect the case that much, but it definitely put me off from the go.
Can you not answer the questions about statement argument, whether the framers intended this in the Constitution?
I did not mention the framers as Constitution.
I'm aware that you did not mention the framers in your brief. However, the Constitution is relevant in this court.
Yes,
And
which
I
my
am
other
asking
attorneys
how
have
the
addressed.
Constitution
Which
applies.
my other attorneys have addressed, if you listen.
It was definitely really intense, a lot more than I thought. Trying to get even like the judges like calm down and whatnot, it's tough. But I mean, they're asking really good questions. The lawyers have amazing arguments. It's tough to refute that. I think way before the case, I kind of was leaning against capital punishment, but to be honest, it's kind of like all up in the air. Like after reading the briefs, it's just each side has such good arguments.
We do not punish rapists with rape. We do not punish arsonists by burning down their house. This is not how America works. The justice system is not about vengeance.
Would you not agree though that murder is much worse than rape and arson?
What?
Would you agree that murder is worse than
I would agree it's worse. That's why it has a worse penalty. But I would not say that that means the theory doesn't apply. We're not based on vengeance. We as a society, we condemn serial killers and sociopaths because they don't place any value on human life, they just kill. But as a government, if we, by killing murderers, we are actually enforcing this belief.
We are very excited to make James Walker not get the death penalty. He does not deserve the death penalty. He will not be given the death penalty. I am very confident of this result, sir.
Texas, you're a minor until the age of 18. Walker, age 16, is still legally a minor. If you look at foreign countries and their execution of minors since the year 1990, we see a periodic trend that more and more countries are stopping the execution of minors. The only countries to execute a minor since the year 1990, China, Democratic Republic of Congo, Nigeria, Pakistan, Saudi Arabia, Sudan, Yemen, Iran, and the United States of America.
Why should international law be regarded as a courtroom?
We are not a country that is beyond reproach of all other nations. We don't sit further away from them. International law has been used in previous Supreme Court cases such as Texas v. Verdeen, 1963, St. Mary's Honor Center v. Hicks, 1993, Meladin v. Texas, 2008, Olympic Airways v. Hussein, 2004. Justice Ginsburg stated, American courts should look more into foreign court rulings and international law.
Great job, folks. Justices, just hang back. All the judges and everybody else is dismissed. I'll see you tomorrow. This is the 6th year, I think, or 7th year we've been doing this, and each year it gets better. This was one of the more interesting sort of presentations because we broke from some of the more traditional formats of head-to-head topic arguments, and we got into more theoretical on both sides, allowing each side to determine their own logic for presenting their side of the case.
Metal under tension, begging you to touch and go.